In this video I want to talk about the Work-Life Balance and Miscellaneous Provisions Act of 2023. This is the act that gives the right to an employee to request remote working. A code of practice was published there this year in March of this year to do with that particular act that was brought in 2023, and this gives an employee the right to request from the employer the right essentially to work from home. There has been a recent case, and there's a number of other cases in the pipeline, I understand, at the WRC, but this particular case, which was involving TikTok, the app, you'll probably be familiar with TikTok, a lady there called Alina Karabko brought a claim against to the Workplace Relations Commission against her employer, TikTok Technology Limited. She argued that the company had failed to consider her needs in refusing her application for fully remote work. So she was looking for fully remote work. She had started in the job in early 2022 during the COVID pandemic, and she was allowed to work from home initially. The respondent later introduced a hybrid working model which allowed 2 days of remote work. The WRC observed in this particular case that Section 2023 or Section 2021 of the 2023 Act, that is the Work-Life Balance and Miscellaneous Provisions Act of 2023, it imposes 3 specific obligations on employers, and they are: 1, that the employer must consider a remote working request having regard to its needs, the employee's needs and the requirements of the code. 2, employers must either approve a request for remote working or notify the employee in writing of its refusal within 4 weeks of the receipt of the request, or extend this period by a further 8 weeks to adequately consider a request before responding. The WRC adjudicator acknowledged that the complainant had made a comprehensive case for full-time remote work. However, the WRC adjudicator found that the company had complied with each of the requirements set out in the legislation. The lawyers, good bodies representing TikTok, said that the case will be welcomed by employers as it reiterates that the right in the Act and under the Code is to request remote working, not to remote work per se. So the employee has the right to request remote working, but provided the employer gives that request a fair hearing and follows the various guidelines, or the timelines rather, within which it must respond to the request and so on, then the employer will probably be covered. Goodbody says that this case highlights the statutorily prescribed limitations on the role of the WRC in considering claims under the Act by employees aggrieved at the fact that their remote working request has not been approved. The fact that the WRC is not empowered to look behind the merits of an employer's decision might come as a surprise and a disappointment to many employees, but this case confirms what the Act provides in that regard. So, to be clear again, the Act provides that the employer must consider a remote working request having regard to its needs, the employee's needs and the requirements of the Code. 2, employers must either approve a request for remote working or notify the employee in writing of its refusal within 4 weeks of the receipt of the request, or extend this period by a further 8 weeks to adequately consider a request before responding. Once the employer does these 3 things, then the employer will be in a strong position to defend any claim at the WRC in relation to a request for remote working, if, having looked at the needs of the business, having looked at the needs of the employee, the employer decides that it is unable to facilitate the remote working. From an employer's perspective, the case outlines the procedural steps that must be taken to comply with the law, and once the employer complies with those procedural steps, then the employer will be in a pretty strong position to defend its case at the WRC, the Workplace Relations Commission. There is no doubt that this case is the first reported case, or certainly the first high profile case involving a request to remote working. It involves TikTok, and there's a certain amount of fame or notoriety to that because everybody knows what TikTok is. But this is the first reported case of its kind. It's not going to be the last, that's for sure. And RTE have reported that figures released by the Department of Enterprise, Trade and Employment showed that up to 30th of July 2024, 18 people had made complaints to the WRC about remote or flexible working. But it is worthwhile noting that if the employer goes through those steps and does what it's supposed to do in accordance with the legislation, well then the WRC's hands are tied and they cannot really go behind the employer's rationale or decision. Hope you find this video useful. If you do, I'd appreciate if you gave it the thumbs up down below, and you may be interested in subscribing to my YouTube channel. Thanks a lot.